Happy Labor Day. Checking in with you about our favorite internet sensation, Jeremy Charles Dewitte, who is still chilling over at Taylor Correctional Institution over in Perry, Florida. And a lot of questions about what's going to happen to him once his sentence is completed. He is scheduled to be released coming up next weekend, September 10th. And as I detailed in a recent video, he has an active arrest warrant out of Lake County. And so he's unlikely to be immediately just set free on his own. But what does that mean? What is going to happen if he is indeed picked up and taken into custody by the Lake County Sheriff? Well, ordinarily, when you're arrested on a warrant, the magistrate or judge who signed the arrest warrant also sets an amount of bond. And so he likely has a bond in the warrant. I don't know what amount of bond he'll have to post. That remains to be seen. We'll have to wait and see once the bond or once the arrest warrant is publicized, once it's released to the public. Ordinarily, arrest warrants are not public information, all the details of it, because, you know, if somebody calls the sheriff's office and says, hey, do I have an arrest warrant? What they'll tell you is, come down and show us your ID, and we'll tell you whether or not you have an arrest warrant. And if you do, you get locked up. So the details of the warrant, other than its existence, are under wraps right now, and we won't really know all the details until later. But in the meantime, I felt like it is worth taking a look at what exactly is going to happen if Lake County does pick him up. After all, it's not necessarily the case that all arrest warrants get executed. The mere existence of an arrest warrant does not mean that somebody is necessarily going to be picked up and taken into custody. I've had cases, numerous cases, where somebody gets pulled over on a traffic stop and they have an outstanding warrant, and they might even be taken into custody. But if the agency that applied for the warrant does not come to pick them up or to pay for their transport, then the arrestee will ultimately be released after a period of time that the applying agency has to come get them. For Jeremy, the distance between Taylor Correctional Institution, where he's at, and Tavares, which is the where the Lake County courts are, in the Lake County Jail, he's looking at about 3.5 hours, 184 miles. So probably not too far. It stands to reason that I would say more than likely Lake County is going to go pick him up and extradite him to Tavares. Never know for sure, though. It's hard to predict in this game. So in Lake County, which is part of the 5th Judicial Circuit here in the state of Florida, there is a standing order establishing a bail schedule. But as we'll see in a few minutes, you know, that could change at the request of either Jeremy or the state attorney's office in Lake County. Jeremy, as far as we know, it's a larceny offense. And so looking down here at the standing order, fraud, theft, grand theft, there's a schedule of bonds that are required to be posted. And the bonds typically range between $2,000 at the low end and $10,000 at the high end, which, if you ask me, is pretty modest in the realm of bonds, especially if it's a felony. That being said, if the state believes that the bond is not high enough, or if Jeremy believes that the bond is too high, either the state or Jeremy could petition the court to modify the bond. the setting of bonds is governed by Florida statute section 903.046. And there are other statutes and rules of criminal procedure as well, but I felt like this one would be instructive on some of the things that a judge would look at when assessing whether or not to set a bond and what amount of bond, if any, should be set. Bonds throughout the United States are not intended to be punitive. They're intended to serve two purposes. One, to make sure the arrestee shows up to court on time. And the second thing is to ensure the safety of the community. Typically, courts regard bond or bail as balancing, on one hand, the defendant's liberty interest with the community's interest in security. So when assessing the bond, the court looks at a number of variables, a number of elements that get factored into the assessment, starting with the nature and circumstances of the offense charged. There are a lot of, some details about what it may be, but we really have to wait to see all of the details to see exactly what Jeremy's going to be charged with. The weight of the evidence against the defendant, if I had to guess, all of the evidence is probably captured on body camera provided by Jeremy, because he's very generous like that. Defendant's family ties, length of residence in the community, employment history, financial resources, and mental condition. D, the defendant's past and present conduct, including any record of convictions. So this is an example of how it's hard to predict exactly what's going to happen. For example, if we look at what Jeremy's in for right now, I mean, sex offender registration violation, 6 counts of impersonating a law enforcement officer at different times, and then violating the wiretap statute. If you'd asked me, I would not have told you that he's likely to get an 18-month prison sentence for all of this, especially in light of his past criminal conduct. I mean, this guy is a frequent flyer with the Florida state prisons. He's served 3 other prison sentences. He's been to prison 3 times. He's serving his 4th prison sentence, and this time was only 18 months. So it's hard to tell, but one of the things that the judge, when setting the bond, setting the bail, one of the things the judge could look at is criminal history. And it's hard to find a period in Jeremy's adult life, an extended period of time, when he was not getting in trouble with the law. So that will definitely come into consideration. Nature and probability of danger which the defendant's release poses to the community, the source of funds used to post bail, whether the defendant is already on release pending resolution of another criminal proceeding or on probation, parole, or other release pending completion of a sentence. Street value of any drug or controlled substance, I don't think that one is relevant. Nature and probability of intimidation and danger to victims. Whether there is probable cause to believe that the defendant committed a new crime while on pretrial release. Yes, almost certainly Jeremy was on pretrial release when he committed whatever kind of larceny is alleged or gives rise to the arrest warrant. Not only that, but he has a history of committing new law violations while on pretrial release. That's certainly something that could and should come into play when the court is not only evaluating whether what amount of bail should be set, but also what other conditions should be imposed on him to ensure the safety of the community, ensure that he's not going to be committing other crimes while on pretrial release, and ensure his presence in court. Any other facts that the court considers relevant. So that's a catch-all. The court has pretty broad latitude to consider relevant information when assessing the bail and conditions of pretrial release. So It's imminent. Any day now, we should get some answers to exactly what's going to happen with Jeremy in his new case. I think it is likely that he'll be permitted to get out of jail. It's just, is he going to be able to post a bond? And what other conditions is a judge going to impose on him? Or could a judge just release him with very minimal bond and no other conditions? I've seen it happen. I've been surprised before. We'll have to wait and see, and we'll keep you updated.